Order all rise.
First resumed, please be seated.
I am on to item 5 of my outline, which is failing to retrospectively consider what the annuity augmentations would have been and failing to consider the historic losses. And it seemed to me as I read through the Crown's reasonings that what has been truly lost is a proper consideration of what the annuities should have been, and hence what the losses were can't be figured out. And the best way I thought of sort of approaching this topic was to sort of center ourselves into what the court said the task was. And at tab 7, I've reproduced a portion of my factum. I'm just going to go over some important things that the court said. And I would summarize it this way, and I do so at paragraph 119 of my factum. The Supreme Court of Canada expressly required that the annuities must be increased with respect to the past in a retrospective way, and that what is to be paid is compensation for the past breaches of the failure to augment the annuity in the past. And they go on to talk about, the Supreme Court does, about compensation for the breach. And so I just wanted to center our discussion on what the court said. So first of all, I say at paragraph 119A, quoting from paragraph 10 of Restuel, the Crown must increase the annuity under the Robinson treaties beyond $4 per person retrospectively from 1875 to the present. I note here, and I should also make sure that on the issue of 1875 to the present, while the Supreme Court of Canada expressly mentions increases from 1875 to the present, as opposed to 1850, nothing turns on this because both Crowns have agreed that the proper period to be considered is 1850 onwards. And even if augmentations would only have commenced in 1875, the first order of business in 1875 would have been to figure out what the Anishinaabe lost from 1850 to 1875 by not having the annuity augmented in accordance with its terms during that period. So we get to the same place anyways. 119B, both Canada and Ontario agree that some level of increase beyond $4 for the period between 1875 and today is required. Again, that's Restuel, paragraph 263. The Supreme Court of Canada said at paragraph 11, the Crown is obliged to determine an amount of honorable compensation to the superior plaintiffs for the amounts owed under the annuities. Then, over on the page, that's compendium page 59, my paragraph 119E, I say, this is towards the end of E, this requires the Crown to pay an amount subject to review by the courts to compensate the superior plaintiffs for its past breach of the augmentation clause. So the compensation is to remedy breach. not simply to repair, just repair a relationship. I have F, paragraph 86, footnote 86, it's paragraph 289 of the Supreme Court of Canada decision. The Crown must increase the annuity beyond $4 per person regarding the past. I want to talk about J, the Crown must provide redress for the conceded breach of its duty. So what they have to redress is the breach. And in K, the Crown is obliged to pay an amount to compensate the superior plaintiffs for the past breaches, or to compensate the plaintiffs for the past breach of the clause. And in L, which references paragraph 290, the compensation to be paid is to redress the harms occasioned by the Crown's neglect. Under M, the court reminds us what it means to diligently and honorably implement the augmentation promise cannot be understood in terms of procedure alone without reference to what the augmentation promise requires. So we have to be centered on the promise itself. And I concluded paragraph 120 by saying, and this is part of my factum, all of the foregoing guiding factors make clear that the quantification of past compensation cannot be honorably arrived at without having an understanding of the quantum of the loss. Each of the foregoing guiding principles has not been honorably considered by the Crowns. And we make the point that the Crowns have failed to turn their minds to retrospectively increasing the annuity in the past, and they have failed to consider the harms and losses caused by their breach, being their failure to pay the augmentations in a diligent and timely way in the past. And the reason why those two elements are so important, because you can't begin to consider what compensation is just and honorable and consistent with reconciliatory justice without having some idea as to what the aggrieved party has lost. And in order to know what the Anishinaabe lost, you need to have a proper bring forward rate. What the Anishinaabe would have done with the collective annuity payments that should have been made and in the past is an objective determination that is unrelated to Crown discretion. And the evidence from stage 3 demonstrated that the money would have been invested for the long term, not spent, not invested in bonds, but invested for the long term. And I'm not going to go through the evidence from stage 3 where we did that. I don't think that's necessary.
When you say, Mr. Schachter, that the Crown cannot, the Crown can't begin to compensate without having an understanding of the quantum of the loss, do you say that the Crown has to engage in the process that we were engaged in stage 3 of fixing the Crown loss? And if you do, this is actually where I'm really going.
Mm-hmm.
How does that reconcile with what the court, what the Supreme Court told us not to do in this review? Not engage in an assessment. I don't have the words in front of me.
I think that they said this stage 3 will not begin as an open-ended quantification or calculation.
Yes.
Right. And the stage 3 won't begin as that, but it might end up there. But in terms of what the parties should have done, the parties in the engagement process needed to turn their mind to what was lost. And the Crown's quite frankly, they need, in order to assess what reconciliatory justice requires, they need to know what was lost. And so there either has to be an agreement or a consensus among all the parties as to what was lost. So for example, let's use Tacohican as an example. They had a good idea. I think the loss was something like $2 million or something. So, there was a definite amount lost. Here, it's much more difficult to know what was lost, but not so difficult, quite honestly, to come up with a range of what was lost. And if that range had been properly identified.
But
Right.
even identifying a range, like one way to identify a range is take the lowest of the lows and the highest of the highs. That range is almost unworkable, isn't it? It's so
no,
vast.
but it's not that difficult. Judges do it all the time because what you make your decision on, what the Crowns and the Anishinaabe have to make their decision on, is based on credible evidence, based on the best evidence available. Now, it would be beautiful if, like in Tacohican, we knew it was $2 million, but we don't. But what we do know is that some evidence was better than others. We do know that some witnesses fared better than others. We do know what a sense. Lawyers do this all the time too. We have a sense of what evidence went over well. We have a sense, and what the party should have been doing is what the judge is going to be called upon to do in this case, which is to define the range. And the Crowns had an obligation, I say, to get that range correct. And if it's not by agreement, the Crowns have to be correct from the perspective of the judge in this review, that the range that they had is correct. And from among that range, that's where you start saying, now that we know, have a defensible range of what you lost, now we can start talking about reconciliatory justice and what add-ons to that is required to remedy, to bring constitutional harmony. So yes, I'm afraid that it doesn't. The Supreme Court of Canada didn't shy away from saying that what's required is annuity calculations. They expressly require that. Annuity calculations. That's it. I think I already made a reference to that. Let me see if I can find it real quickly. $294 maybe?
Yeah.
Yes, paragraph 294 talks about annuity calculations having to be done for the past. So, I mean, the court's not shying away from that. I mean, what the court is saying, you got to figure out what the annuity would have been. You got to figure out what the parties would have lost. Now, the practical problem facing the parties is, what do we do about figuring out what was lost? Because all the evidence has to be sort of reconstructed after the fact. Now, to some extent, I've already given you some law that the Anishinaabe should not be penalized for the lack of that evidence, but there is still credible evidence on which the parties could have based a range on. And I believe in our factum, we come up with a range that we say is defensible based on the facts. We say as well that the $3.6 billion amount is not defensible based on the facts because it's really just based on Bodway and Smart's analysis, which is not worthy of weight. Not in the in the marketplace of ideas and in the testing of evidence in court, which is the best way that we know of in our democracy to test credibility and reliability. Bodway and Smart did not fare as well as Stiglitz and Hutchings. Now, and when it comes to bring forward rates, Canada's witnesses did not fare as well as the plaintiff's witnesses. But all of that can be discussed and should have been discussed among the between the Crown and the Anishinaabe. And there should the process that we had tried to develop would try and bring the parties together in identifying a realistic range of compensation of losses. And that was never done. That realistic range and that cooperative effort failed pretty close to the beginning of the engagement process, when the process that we had developed and wanting an agreement on a process fell apart. But that's the process that has to be done. And I appreciate that the Supreme Court of Canada said, look, it's not going to begin as a calculation. Fair enough. But what needs to happen, what needed to have happened, is the parties needed to turn their mind to it. And this is going to force the court to turn its mind to what is a realistic range in order to know whether the Crowns came within that range. Because this court can't know if it's honorable, liberal, or just without knowing what was lost. This court's going to have a sense as to what was lost. And what was lost depends on what the annuity should have been and what the Anishinaabe would have done with their collective share of the annuity over the years, which brings in forward the interest rate. So it's not a simple task of just picking out a number. I mean, I suppose if there had been a settlement based on ignoring, I guess the parties could have simply said, we don't care about what was lost. But the plaintiffs didn't say that. The First Nations didn't say that. The First Nations say what the Supreme Court of Canada says. Figure out what was lost and apply reconciliatory justice principles to that and come up with a number. That's where we should be at. Now, the court may have some more questions for me on this, because it is a big task to figure out. And we think we did the best we could in stage 3 with the evidence that we brought. We think the court is in a good position to have a good sense of what evidence was good and what evidence was not. We think it was unreasonable, incorrect, however you want to describe it, for the Crowns to dismiss the plaintiff's stage 3 evidence in all but substantively dismiss it.
Or is another way to put it that the parties went through the engagement process maintaining the positions they took in submissions at stage 3? Well,
No, the First Nations didn't. They compromised significantly. Both on the record, you will see significant compromises in principle and in dollar terms. Not so much so the Crowns. From $0 to $20 million is where they came to.
But I wasn't actually thinking of the number.
Okay.
You said the task. The task is a huge task. We use those words a lot in stage 3, that the task, and I think you're suggesting the task remains. The stage 3 task remains.
Yes.
Is that what you're saying?
The stage 3 task remains because the parties in the engagement process are not able to give you more. Sorry, I shouldn't say the parties aren't able to give you more guidance, because there is more additional evidence from Hutchings and additional evidence from Bodway, which admittedly is not trial tested, which is not challenged.
Which I wanted to talk to you about whenever you get there.
Well, let's deal with that for a moment right now, because I recognize that as a potential problem. In the engagement session, when this new expert evidence started coming out, I said, look, the Anishinaabe, we want the decision maker to have the benefit of the best evidence. We don't want them to make decisions on evidence that hasn't had an opportunity to be challenged. So why don't we have the experts show up and they can be questioned and we can have a dialogue and make sure that if there's faulty reasoning in any expert's path, it's uncovered so that the decision maker has the best possible evidence. We would do the same thing for a judge. That was rejected by the Crowns. We expressly asked for it on more than one occasion and they said not interested. And I say they do that at their own peril. They've left the court with a difficult task. I mean, of what do you do? What does the court do with this additional evidence? How does the court possibly weigh it without having it being tested before the court? My position on that is it's a one-way street, really. We offered the opportunity to challenge Mr. Hutchings on any of his new data. They chose not to. We asked for the opportunity to examine Mr. Bodway on his data. They refused to allow us. So my position on that is this court should accept Mr. Hutchings' new evidence as having been tendered in an unchallenged way, and should not accept Mr. Bodway's evidence as having been tendered with any challenge. You can consider it, but know that we didn't have an opportunity to challenge it, other than Mr. Hutchings did respond to most of the complaints made by Mr. Bodway. So most of it's in Mr. Hutchings' response. So that's how I think you should be dealing with the new expert evidence. But you were asking a question, and maybe I've lost my train on where you were actually, your question was going in terms of having to now figure out what the range of losses are. The parties didn't do it. The court's going to have to. The court's going to have to, based on the stage 3 evidence and whatever evidence it feels from the engagement process helps it, to arrive at, to be able to decide if the range is, if the 3.6 billion is within the appropriate range.
What do you say the parties did not do? They did not agree on a range?
The parties didn't even remember in Takuhikan, I made the mention of and you should be negotiating and trying to reach an agreement. We tried to reach an agreement on a process, and that didn't happen. And that process agreement that we had put forward was a rather detailed one that allowed the Crowns to disagree with us on any element, as long as they identified what they were disagreeing with, so that there could be structure to what was agreed to and what wasn't agreed to, and hence we could narrow the field of disagreement. The Crowns, Ontario in particular, said not going to do that because that's just fetters our discretion. Well, with respect, I say that's wrong. It's not fettering Crown discretion. It's not fettering ministerial discretion for the minister or for the legislature or parliament to come up with rules of the game. That's all we were trying to do. Coming up with rules of the game, what factors you will look at, how they will be looked at, how will they be weighed, what factors are important for the exercise of discretion. All of those is not fettering of discretion, it's the exercise of discretion. Legislature does that all the time when they legislate or regulate. They put parameters around what was once the Crown prerogative, right? And once you put parameters, you got to follow the legislation. There's nothing wrong at all with with what the Anishinaabe proposed, which is let's have some rules of the game so we can narrow the differences between us, and at least know in a principled way what people's position is before a decision is made so we can address it. Now, the Crowns have said, well, really what you're just trying to do is dress up your argument from stage 3 into principles. Well, I don't think that's a fair criticism. What we're trying to do was you can have your principles and we can have our principles. Let's try and work out a settlement by identifying what those principles are, agreeing to a process, and at least if we knew what how the Crowns were going to approach their discretionary decision, we could either marshal additional evidence or speak to what it is their decision was the parameters that were important to the Crowns in the exercise of their discretion. We didn't get that. What we got was, we're listening to you, tell us everything, and ultimately it's our decision, says the Crown. That was not a sufficient enough engagement process. Getting back to the importance of identifying what the loss is, the Crowns didn't afford a sufficient opportunity for the parties to do that collectively. They have unilaterally identified the losses themselves. They didn't identify the losses. They identified a quantum of a payment without identifying what the losses are. And we say this court simply cannot appreciate, you could rule that the whole process is faulty and therefore, the decisions can't stand, but you can't make an informed decision about what the proper range is, which I would call the correct number within an appropriate range. You can't do that without having a good sense of what we lost and what the Anishinaabe lost. And that shouldn't trouble you, actually. And you know what, let me turn up Taku-Hicken again, because the minority judge in Taku-Hicken addresses this very problem. This is at tab 6. Bear with me. Paragraph 321 of Taku-Hicken, the minority, I think it was Justice Cote? She says,
I'm just going, is that page 54?
hold on, let me make sure. Yes. This exercise might pose some additional difficulties when it comes to remedying a breach of the principle of the honor of the Crown. Indeed, if the court chooses to resort to damages as appropriate compensation, identifying and precisely quantifying injuries such as the loss of a police force culturally adapted to the needs of the community can sometimes be complex. That being so, the difficulties are nothing new for the courts, which have long been required to use their discretion in determining an indemnity that is fair and reasonable, having regard to all the circumstances. Indeed, on an assessment of an injury involving largely unforeseen or unquantifiable factors, courts must, in addition to making this calculation, rely on a certain amount of approximation and estimation, and as well as their own discretion. So the lack of definitive data for either the Crown or for the parties is not an impediment to justice. The court does its best that it can do, and the parties, well, I'm going to only speak for the Anishinaabe. The Anishinaabe have done the best they can to marshal what they could based on the fact that much of the evidence is not of it is difficult to know because the Crowns didn't keep track of the evidence. But what we could do, we have provided. And the Crowns have said, we just don't buy what you're selling. But they don't have the discretion to decide what the facts of history are. They don't get the amount, the actual historical net Crown revenues extracted by the Crown over the years, which the Supreme Court of Canada calls the benefits. They don't call it resource rents. They don't call it NCRRs. They call it the Crown benefits. Those Crown benefits extracted in each year from which an annuity could have been paid. That's a historic fact. Might be difficult to know, but the Crowns don't get to decide retrospectively what they think the benefits were. That's a matter of fact for this court. And this court is in the best position to decide what the correct answer is to that. Now, admittedly, the court, I don't think the court can come up with one correct number, but can the court come up with a realistic range based on credibility, reliability of evidence? Yes, absolutely. And is that range, is 3.6 within that realistic range? No, it's not. For the reasons that we articulated in stage 3 in closing, the evidence just does not support such a low number. And that's principle.
One of the things I recall saying in stage 3 when confronted with the evidence was, what guidance can counsel give me, all counsel, if, for instance, I agree with the plaintiffs on expenses and agree with the Crowns on something else and agree with the plaintiffs on, I don't know, share and agree with the Crowns on bring forward rate. Where does that leave the court?
I think it leaves the court with identifying a range. Like,
Well, you can't identify a range if you don't know how to do the work of when you arrive at nominal amounts of losses.
right, yes,
My understanding, it was more than what my iPhone could do to, with me directing my iPhone.
oh, okay.
To come up with,
So,
bring forward loss rate.
right, okay, so I understand the question now. If the court feels that after looking at the evidence that it needs the help of experts, the court can call upon experts.
Well,
If it needs
one of the
mathematical
things-
calculations.
I think we might have had this discussion before, and I think wasn't one of the answers that the court could just say, perhaps, here's what a nominal rate, here's what I think, here's what the court thinks is a range of nominal,
Right,
of the nominal amount, and here's an approach on bring forward,
right.
then send it back.
Well, you could send it back, or you could, well, we would prefer some finality at this point, and we'd prefer you actually hire your own economist to do the math and just include that in your decision if it came to that. But
Or should you each provide an economist who goes into a locked room and
that would be acceptable as well.
allowed to come out when they,
There's nothing wrong with the court saying, the court needs some help. Give me some economists to help me.
because what you say is there are 3 factors that go into the assessment.
Yeah, three main
3
factors.
main factors.
Yes.
Right. The nominal amount, the share,
Yes,
and the bring forward rate.
that's right.
So there could be, the court could accept different positions on each of those three.
That's right. That's right. And the court has, it's within the rules and the inherent jurisdiction of the court to call upon an expert of its own. And we would rather see you do that than have the parties spend another 6 months attempting to reach agreement, on matters that I don't have a great warm fuzzy feeling that we would be as successful as the court might be on its own. Having said that, I believe that there is enough in the evidence already for the court to conclude, you know what, I can't do a precise calculation without the help of an expert. But if I accept this factor and accept that factor, I know it's going to fit somewhere within this range, right? And so from within that range, and remember, it doesn't, this is an assessment. It doesn't have to be an exacting science, but it does have to be rooted in reliable evidence, right? There's going to be a range, and I'm willing to venture that the court, without additional evidence and without economic help, has a good sense if I were to accept I'm going to use an X% bring forward rate instead of an X.5% bring forward rate. I have a good sense of where that would fit because I've got all these charts from Hutchins and Bodway and Smart that tell me if you use certain percentage figures, what the output is. So
Not like a mortgage calculator, though. I can't move that little piece of cardboard over to the nominal rate.
no, you can't, but you can't be precise, but you can be within a range. And that's all we're asking for. We're asking not for precision because it's an artificiality anyways, right? We're not asking for precision, we're asking for justice. And justice in proportionality always comes within a range. So, I don't know if
No, that's helpful.
it's what I think the court has to do to be able to make a decision, is to know what the loss was. And the easiest thing the court could do is just accept that our interpretation of the loss is the correct one.
There is always a simple answer to every complicated question.
Yes.
It's usually wrong.
Okay. I want to turn to, unless there's any more questions on item number 5, I would turn to item number 6, which is failing to take into account the indirect benefits actually captured. I touched on this earlier. Just want to make sure that the court has these points. All experts agreed that over and above direct net Crown resource revenues, the Crown actually historically does indirectly capture more benefits relating to resources from within the territory than is shown simply as an NCRR calculation, direct capture. And if you need a site for that, you can see at Compendium tab, I'm not going to pull it up, but I'll just reference it. Compendium tab 8, this is January 6, 2025 report of Hutchins, record page 3401, where Hutchins confirms Bodway's confirmation that everyone agrees that there's indirect capture. You want me to turn that up? Sure.
3401.
Yeah, that's record page 3401. And at paragraph number 8.
Compendium page 68.
Compendium page 68, that's correct. In the middle of the page, Professor Bodway acknowledges that all economic experts agreed that the Crown did capture some rents indirectly, and says the question we should focus on, what is the magnitude of each indirect rent capture? We agree on the question. He disagrees with my conclusion that a range of 25 to 30% was appropriate and likely conservative, and instead offers several criticisms of my analysis. We're going to see that ultimately Mr. Bodway Ontario comes up with a little bit of a different approach than Hutchins, which is basically 25% of NCRRs instead of 25% of the difference between rents, 25% of the difference between rents and NCRRs. Now, if you look at the math, it's almost the same. It comes out to be the same. So
The same as what?
Hutchins' calculation of 25% of the difference and Bodway's 25% of NCRRs. If you use that formula, I don't know if it was Bodway's as opposed to Ontario's, but if you accept Ontario's, let's just take 25% of NCRRs, you get very, very close to the 25% that Hutchins was using. Now, Ontario actually accepts the fact that there is indirect capture. Canada does not. At page 27 of their decision letter, Canada accepts that over and above NCRRs, Canada indirectly captures additional rents from resources. And I want you to remember that some rents from resources are captured directly through NCRRs, and Stiglitz and Hutchins showed some rents are captured through income tax. Now, after making the concession that there are indirect captures, Canada, in the very next paragraph at page 27 of their decision letters, ignores the very proposition and then claims that indirect capture is not closely related to resources. Respectfully, this is an error in the reasoning path. The only indirect capture the experts were ever talking about was indirect capture of a portion of the resource wealth. It's not some unrelated indirect capture. It's capture specific to the resources themselves. Ontario appreciates that. Canada did not. So the only legitimate issue about indirect capture is how much of the resource wealth is indirectly captured by the Crown. Now, in his latest post-stage 3 report, Bodway for the Crown estimated the capture rate to be 16%. But in Hutchins' reply report of January 6th, Hutchins pointed out that Bodway had been looking at data that only accounted for the federal portion of the capture. Hutchins, once again correcting Bodway, observed that if one adds back in the provincial recapture, the rate approximates 25%, the very rate that Hutchins proposed. And you can see this analysis by Hutchins in his January 6, 2025 report, Compendium tab 8, record page 3405.
But did you say earlier that, I don't know if it was Mr. or Professor Bodway got to 25%?
No, sorry. What happened is that Mr. Hutchins had done, you might recall that if you read the information about the engagement session, I don't know if it was Ontario or Canada, but there was concern raised that at the stage 3 trial, there wasn't sufficient evidence about indirect capture. And it was decided that we would provide additional evidence. And so Mr. Hutchins provided additional analysis and looked at the indirect capture to see, is the 25 to 30% range that was offered up in stage 3, is there more support for that? Well, it turns out when Mr. Hutchins did a little bit more work, that he was of the view that, well, it's probably better to say that it's closer to 25% than 30%. So he reduced his estimation based on additional data. Mr. Bodway replied in a report. I don't have what's the date of that report, Ms. Lewis?
December 14th, I believe, which is the second.
Anyway, Mr. Bodway replied in a report and said, Mr. Hutchins has it wrong. It's not 25%, it's 16%. And he provided as proof of that, I believe, a paper written by Jack Mintz. And then in Hutchins' reply report, which is the part that I've just referred you to, the January 6, 2025 report at record page 3405, compendium tab 8, compendium tab 72, he points out that Professor Bodway got it wrong because Mintz was only looking at federal recaptures by income tax, not the provincial. If you add back in the provincial portion, you get to 25%. Now, at the end of the day, and I suspect likely knowing that Hutchins was once again correct, Ontario has finally conceded that which respectfully should have been conceded in 2023, that over and above direct capture of NCRRs, the Crown indirectly captures more. Now, Ontario then includes in its calculations, and you can see this at their decision letter, paragraph 14.
You said, I just want to check this. You said compendium tab 72?
Compendium page 72, yes.
Thank you. Go ahead.
Yes, this is one of those reports, by the way, that we offered up to the Crowns to, if you don't, if you think it's wrong, we'll bring Mr. Hutchins and you can question him on it. And they said, no, have no interest in doing so. Ontario includes in its calculations as a indirect capture 25% of NCRRs on top of the NCRRs. Now, for past compensation, not future considerations, we, the Anishinaabe, have no objection to the principle of valuing indirect capture to be shared as being calculated as 25% of NCRRs. It gets us close enough to 25% of the difference in rents. So as to,
What were you just reading from?
I was reading from my notes.
Oh, okay, sorry. So if I'm at pages 72, 73 of that report, that's what I'll see.
At page 72, 73, you'll see Hutchins explain how Bodway got it wrong, that it's not 16%, it's actually 25%. And the point I moved on to was Ontario comes up with a fairly decent principle to work with for past compensation. They say, forget about 25% of the difference between rents and NCRRs. Let's just use 25% of NCRRs. It actually gets us, if you do them, and you can do the math yourself, you don't need an economist for that. Just take Hutchins NCRR multiplied by 25%, and you'll see that the ratio is very close to the same. So I'm not here, I mean, it's not precise. It doesn't follow Hutchings' analysis, but it gets us to a place that it's not worth arguing about, the 25%. We can accept it for past compensation. Of course, the devil is always in the details, and the principle of 25% of NCRRs for the past is okay for the past because it's okay in principle, but only if the NCRR number is correct. If the NCRR number is too artificially low, it's meaningless. So with Ontario's NCRR calculation equating to about 2% of what Hutchings' NCRR calculations is, an extra 25% of 2% is not a lot. It yields an inappropriately low number. If the correct NCRR calculations are used by this court, or if the parties in the engagement session had the ability to come together to reach an NCRR quantification and not ask the court to have to do it, then the total Crown benefits captured for the assessment of past compensation is really off to a good start because we can just plug in the 25% of the proper NCRR amount and you don't have to worry about rents at all. Now, the reason why this 25% of NCRR works for the past is because the polycentric decisions that the Crown made about which resource to extract and when and how and what incentives they would give so that they'd only captured so much. Those decisions are passed, they're made. But in the future, we have a problem because in the future, we don't know how the Crowns will arrange their affairs. And if they don't capture it by way of NCRRs, but capture it only by tax, then or some other means that are not part of NCRRs, then the 25% of NCRRs won't work. So it's so my concession, if I can call it that, or my agreement to a principle of 25% of NCRRs, it works for the past only because if you get the correct NCRR calculation. Is that, I don't know if I've been
Yes.
clear. I hope I have. It is 3 o'clock. Did the court when is the court thinking of sitting till?
Till 4:30, I think.
Okay.
Does that work?
Yes,
So a break at 3:15 or?
break at 3:15. Okay. Let me go on then to item number 7 which is the problem of using the incorrect bring forward rates. Canada's explanation in its decision letter of January 27th at page 28 explains their rationale as to why the bond rate is an appropriate bring forward rate. Canada bases its rationale for using the bond rate is that the bond rate actually captures what the Anishinaabe would have done with the money. This, respectfully, is not a fair characterization of the stage 3 evidence at all. The stage 3 evidence says Canada excuse me. The evidence from stage 3 does not support Canada. The evidence from stage 3 is that the Anishinaabe would have invested for 7 generations. They would have invested in themselves and their health and education, all of which the evidence from stage 3 shows have actually higher rates of return than the 60-40 market rate. Moreover, at page 28 of their decision letter, Canada errs in law when it posits that the 60/40 rate is tied to a rate available only as an incident of remedying a breach of fiduciary duty. This is an error of law. Firstly, a reconciliatory justice payment may, as a matter of law, require equitable type compensation principles to be applied. The court can be as creative as necessary. Canada failed to consider this. What bring forward rate to use depends on the unique facts and the court's consideration of what would be just, generous, and liberal and honorable. The bond rate is not that. Evidence was not that the Anishinaabe were risk averse. The evidence was to their contrary. One need only look at how risky of a proposition it was in 1850 to roll the dice with a new treaty partner, that the future wealth that might be exacted would be subject to not the whim of the crown, but the goodwill of the crown, the honor of the crown, not knowing whether there'd be any wealth at all. Remember what they gave up. Other First Nations were getting $10 per capita, and what they ended up getting was a promise of what amounted to about $1.68 per capita on average, and a promise for a share of more. Another way of,
You say they gave up $10 a person?
there was discussion of a fixed per capita, sorry, not at the treaty talks, but at the time, other First Nations were getting $10 per capita.
Right. But I thought you were describing a bargain. They gave up X or Y.
Well, no. If you're asking the question, if one asks the question, are these people risk averse or not? Then the answer to that is, let's look and see what they did in 1850. In 1850, they eschewed having certainty. They eschewed having a $10 amount. And instead they said, forget about a $10 amount. We'll take the lower amount and take whatever the future might bring. Because we have confidence in the future, we have confidence in our partner, we're willing to share whatever it was. They are not risk averse. And if you remember the evidence in stage 3 about the chief speaking to the saving for 7 generations, and I believe it was Booth and Kersner had evidence of the band trust accounts showing a lot of saving, not spending. So to suggest that the Anishinaabe are risk averse and would have invested in long-term bonds is just not consistent with the evidence. The evidence is they would have done, sorry, the evidence is they would invest for the long term. The evidence from the experts is if you have a long-term horizon, the more you put in equities if you're in the marketplace.
There are 2 questions I have arising from this.
Yes.
And the first is, was there a point ever where the Crown experts agreed on those rates of return for investments in health and education? Or do you recall?
Maybe we can jot down to see if we can find it. I do not recall that happened. I believe, my recollection was that Stiglitz and Hutchings had one rate, a number of rates for that.
Yes.
It was not that far off from Booth and Kersner's on the rates of return on social capital.
Okay.
They were both very large. I believe I might even have. Oh, that's it. I left that at, yes.
You can come back on that.
Okay.
Yeah, it'll have to be tomorrow.
Okay, and the second question was then, when you make the argument that you start making the argument that the Anishinaabe were not risk averse, and so they could have put it in the market. Are you distinguishing between putting it in the market and spending it on social capital? Are you distinguishing the calculation that you would make with a bring forward rate that is based on the market? And are you saying that could have included spending on social capital?
No, my argument is a little bit simpler than that. If you had spent it on social capital, you would get a greater return than 60-40. Right? So even if you accept, if you accept that some of it would have been spent on social capital, sending people to school, better, healthier outcomes, right? The rate of return would exceed 60-40. So that is why Stiglitz, as part of his evidence, said that's why 60-40 is conservative.
But does the Crown ever answer you on that? Or is the answer on bring forward rate in response to the plaintiffs always on a presumption that it would have been invested in the market? Which is just, like it's a different
Yes,
going on. It's a different
I believe Booth and Kersner had their own opinions about the allocation of what would go into capital and what would go into bonds and the like. And consumption, which had a different.
Well, there was a whole debate about what was consumption.
Right. Well, and there's also the better view accepted by, some judges in the specific claims tribunal, and perhaps some other judges, that consumption has to be, you have to presume that consumption has a rate of return, right? On the theory that if I'm going to consume something instead of investing it, and making a choice. And so my choice must be at least as good as the consumption, as the investment rate I could have gotten. And Stiglitz and Hutchins testified to that. Stiglitz particularly testified to that. That was originally accepted in the specific claims tribunal by an economist named Arthur Hosius, who has since passed away. But what's that case name? It's no, it's not Whitefish. It's a specific claims tribunal.
Decision of Justice Slade, perhaps?
Justice Slade, Okamanis and Beardy is one of them. The other one was the Hayut case. So there was Okamanis and Beardy's, which may be Slade, maybe not. I don't recall. And there's the Hayut case. What?
Then.
But
I think Justice Zinn in Southwind also accepted it. Yes, that's correct.
The question was, are there two parallel arguments going on here between the plaintiffs and the Crowns on the market, on the likelihood of the Anishinaabe investing? One part of the plaintiff's argument is that the evidence shows they would have made investments in social capital, or they could have made investments in social capital. Had they made those investments, there would have been returns of rates higher than the market.
Yes.
That's one argument.
Therefore, but the argument is, therefore, the 60-40 rate is the lesser of the two, so use that.
So if, though, the Crown problem is, well, that just doesn't make sense that somebody in Pick River was playing the market in 1901, okay? If that's the argument, is there a response to the part of the plaintiff's argument that they would have invested in social capital?
No, not that I
Did you recall?
Yeah, at stage 3, Ms. Lewis is reminding me at stage 3, there was that kind of discussion, but it didn't materialize in the engagement process. Canada's decision letter doesn't engage with that. Canada's decision letter says bond rate only. And towards the end of my presentation, the point that you're making about, well, I'm not sure, the Crown might say, I'm not sure people in 1906 would have invested in the market, right? You'd be surprised if you have a large pool of capital, who comes to help you invest it. That's number one. But number two, when we get to the end here, you'll see what the Anishinaabe did is they said, you know what? Let's give some weight to that concern. Let's just take a bond rate, a band trust account rate all the way up to 1951, when everybody knows, and I believe a number of Canada's experts said, when you get to 1951, that's when First Nations could invest on their own. And certainly by 1951, if the law was allowing Anishinaabe to invest, then they could use the bond rate, the 60/40 rate. So in our proposal, we basically acknowledge, on the record proposal, we acknowledge saying, let's give some credibility or some heft to that concern. Not because we don't think that the Anishinaabe would not have invested in the marketplace, because we know that even the Six Nations back in the 1800s were investing in the market. Didn't turn out so well for them, but with a professional investment manager who wouldn't have stolen their money, they would have done just fine. The point is that if you have a lot of capital, people will be knocking on your door to help you invest. But even if you give some credence to, come on, you wouldn't have invested in the market, you would have just let Canada do it for you. Okay, we could live with that and said, here's how reasonable we are. We'll take the 60/40 after 1951.
And the band trust.
And the band trust account before that. Like the theory would go, following along the concern raised, you wouldn't have really done it. Well, what would have happened if they did get the scads of money they should have gotten back in 1857, 1862, 1875? 1883, what would have happened with that money? Well, one of the things that could have happened, but there really isn't evidence about this, it's speculation. They could have gone to Canada and said, you invested for us. And Canada could have put it in the band trust accounts, right? You know, when they were created. That could have happened, that's speculation. But in our approach, trying to be reasonable and accommodating and listening to the concerns of our treaty partner, we tried to give it some heft. This is part of compromise. This is what the parties are supposed to be doing. So the effect on that is billions and billions and billions of dollars that the Anishinaabe are saying, for the sake of harmony with our treaty partner, we are prepared to forego. This is why their proposal is not for $126 billion, but is for a modest $35.696 billion. And that's found in our January 11th, 2025 letter to the Crowns, in which we explain how we arrived at that modest amount. And I know it sounds a little bit odd to say modest amount when we're talking $35 billion, but in the context of what was truly likely lost and the opportunity lost, it is not unfair to characterize it as modest in these circumstances. That letter, by the way, is contained at tab 29 of the compendium. It's 3:15 and maybe we should take a break.
Let's take 15 minutes.
All right.
Or sit down for 15 minutes. Of course, resumed. Please be seated.
Where we left off before the break was discussing the 60/40 rate of return and the on-the-record concession that the First Nations were happy to live with, that would yield a fair amount that they were prepared to live with. But I wanted to get back on track and dealing with why the bond rate is not correct. Remember that I had said that at page 28, Canada said you can't use a 60/40 rate because that's a fiduciary rate. And my first response was, well, given what reconciliatory justice means, it's not fair to say that reconciliatory justice wouldn't use a 60/40 rate and wouldn't use equitable-like principles. But more importantly, the stage 3 evidence supports the use of the 60/40 portfolio. An evidentiary basis is not a presumption. It is proof. The evidence of spending and saving patterns and the 7-generation principles spoken so eloquently by Chief Tangi, I believe it was, supports this. It must be remembered as well that the annuity funds would not be Indian monies, would not have been deposited in the band trust accounts. And so the question is, what would have happened to them? Would they have just sat there? Would they have entered into an agreement to put them in the band trust funds? And this is when we got into the discussion of band trust rates to 51, commercial rates thereafter. At page 28, Canada next invokes the mantra of the wider public interest in choosing a bond rate. Respectfully, this is an error of law and an error in the reasoning path. It is an error in law because, as Southwind makes clear, and here we can turn to tab 9 of the compendium. And go to para 12 of Southwind. Now, Southwind was dealing with a fiduciary case, but intermingled with it is discussion of the honor of the crown. And at paragraph 12, the Supreme Court of Canada says the fiduciary duty imposes heavy obligations on Canada. Well, other cases have said the honor of the crown is a heavy obligation as well. The MMF says that. I think that comes maybe even from Haida Nation. It's not a point in dispute. According to Southwind, at paragraph 12, page 98 of the compendium goes on to say, the duty does not melt away when Canada has competing priorities. Well, the same rings true for implementation of treaty constrained by the honor of the crown. The duty under the treaty does not melt away when Canada has competing priorities. It is an error in the reasoning path because nowhere is there any evidence or discussion in the reasons supporting that the wider public interest is served by choosing a bond rate. In fact, Canadians, as a greater body politic, have an abiding interest in seeking treaties honored. To somehow suggest that there's a wider public interest in ensuring that Aboriginal people do not have money is not appropriate. If what Canada really meant to say, but did not want to say that was, but say something different, that doesn't help them now. They have to be judged by what they reasoned, not but what they could have reasoned. And I just refer you to, you might remember that even in judicial review, York Region, at paragraph 68, Justice Rowe says, look, I can't give them the benefit of the doubt. This is what they said. If they said something else, I can't, it can't support their decision now. Maybe I should turn up to.
Well, what, are you referring to something specifically when you say if Canada really meant to say something, but
No, if Canada meant to say something different, I don't, to say that the wider public interest supports that the Anishinaabe should not have more money than a bond rate return, what's that got to do with the wider public interest? I just simply don't understand the argument. And if they meant to say something different with that, it doesn't help them now because that's what they said at page 28 about the wider public interest. I just don't understand their argument. And if they come up in this before you and say, in argument, saying what we really meant to say or what the minister meant to say, what is really what he could have said, what he should have said, they can't do that. That's offside. When you review decisions, you review for what the decision maker actually said, not what they could have said. That's an important principle of law. And I just cited Justice Rowe from paragraph 68 of York Region, which if the court wanted to look at it, is found in tab 5. At compendium pages 32, 33. So Canada's reasons for why it chose a bond rate don't add up. They're not worthy of acceptance by the court and should be rejected as being either reasonable or correct. Ontario has a very different approach to the bond rate. Ontario claims that the bond rate is the proper rate, not because it is a rate that the Anishinaabe would have invested in, but because the losses caused to the Anishinaabe in the past actually do not need to be considered. If you look at Ontario's decision letter at paragraph 138, and I'm going to read from it, because this is their argument. This is the minister's decision. Moreover, the long-term bond rate is the best indication of the benefit to the Crown for the purposes of factor 3. The focus of the analysis under this factor is the amount by which the Crown benefited from the treaty territory. Given the Crown's past breaches, the Crown's benefit includes the amount of interest that the government either obtained or saved by non-payment. That's the bond rate. By not paying augmented annuities in the past, the Crown would have been able to decrease the amount it needed by borrow by issuing bonds to meet government needs. What they're saying there is measure our obligation on a bring forward rate, not by what the Anishinaabe lost, not their loss, but what the cost of performance would have been. A bond rate that measures the savings that Canada made by breaching the treaty has nothing to do with the harm caused and the loss incurred to the Anishinaabe. And in no instance is using such a rate liberal, generous, or just. It actually rewards the Crowns for 175 years of breach. Ontario's legal error here is similar to the error that Canada made in Southwind. You might recall that in Southwind, which is at tab 9 of my material, Canada claimed that the equitable compensation in that case should be limited by its cost of performance. In other words, what would have happened, they said in Southwind, you Anishinaabe should get, you First Nations, excuse me, should be compensated not based on what you lost, not what your lost opportunity was, but what it would have cost us to expropriate your land, because we could have done that. So our cost of performance. No, said the Supreme Court of Canada. That is the wrong lens to deal with it. True, the case was a case of fiduciary duty, but as I'm going to take you through, you will see why in the context of an appropriate reconciliatory justice remedy, it's a good analogy, whether it's fiduciary or not, because both are linked to the relationship and the honor of the Crown. So there's a number of excerpts from Southwind that provide guidance. Given what Taku Hicken says about remedies and what Southwind says about the honor of the Crown, there are some important lessons to be drawn. So I want to first start at paragraph 66 of Southwind, which the court will find at page 99. The court says, as I shall explain, equitable compensation is a loss-based remedy that deters wrongdoing and enforces the trust at the heart of the fiduciary relationship. Now, you could say pretty much the same thing about reconciliatory justice and the honor of the Crown, because the focus, like equitable compensation, is dealing with the heart of the relationship between treaty partners. And it differs from common law damages because of the unique foundation and goals of equity. You could, given Taku Hicken, it differs from common law damages because of the unique foundation and goals of the honor of the Crown. It then goes on to say the trial judge must begin by closely analyzing the nature of the fiduciary relationship. And so one of the factors then is the relationship, whether it's a relationship of fiduciary or whether it's a relationship of the honor of the Crown and brought about by the sacred bonds of treaty, it is still a relationship. At paragraph 73, when it comes to compensation, the Supreme Court of Canada says, when looking at the differences between equitable compensation and common law compensation, and now we have reconciliatory justice compensation, due to these differences, rather than relying on common law principles, McLaughlin J. explained that the proper approach to equitable compensation, we can substitute for that reconciliatory justice compensation, is to look to the policy behind compensation for breach of fiduciary duty, you could say breach of the honor of the Crown, and determine what remedies will best further that policy. That very much tracks what Taku Hicken says about an appropriate remedy going above and beyond the common law damages. Then if we go to paragraph 77, at the bottom of page 101, we see the Crown's fiduciary duty is grounded in the honor of the Crown and breaches of the duty are different in kind than private law breaches of contract or tort. So here we have a comparison of the honor of the crown, of fiduciary duty coming from the honor of the crown, and the difference between private law duty and public law duty, which are mirrored in Takuhikan. By the way, I want to pause. I am not suggesting that there is a collapsing of fiduciary duty into honor of the crown. I'm not. I am suggesting that we can learn something about appropriate remedies simply by way of analogy if we understand what Takuhikan requires of reconciliatory justice, because you'll see that it's pretty much similar to the requirements of a fiduciary duty. And it's all, if I can say, as a result of the relationship of the parties. In one case, fiduciary, in another, the honor of the crown. Now, I want to turn to paragraph 81, which I believe has applicability in this case. There are additional equitable presumptions that are applicable in appropriate cases. The presumption of legality, discussed in more detail below, prevents breaching fiduciaries from reducing compensation by arguing that they would not have complied with the law. Well, the same goes for the honor of the crown. You can't, an honorable treaty partner would not seek to limit or reduce their compensation owing by arguing, I wouldn't have complied with the law. I wouldn't have paid you your treaty monies. And in effect, really, that's what Ontario is saying. They're saying, you know what? We didn't pay you your treaty monies, and the benefits that we have to share with you, we're going to figure out what the crown benefits were in 2025, and we're going to ignore the benefits we would have given you in 1922, and ignore, therefore, what you could have done with those benefits. That's a wrong-headed way of looking at this treaty promise. Canada doesn't look at it that way, to their credit. Ontario does. Paragraph 128, over on page 105. The Supreme Court of Canada talks about deterrence. And I know the crowns, both crowns, I believe, and we'll talk about this later, say deterrence isn't a factor because it can be presumed that the honor of the crown is going to deal with it. In Southwind, deterrence aims at the fundamental goal of reconciliation and upholds the honor of the crown. So in Southwind, the Supreme Court of Canada says, in order to achieve reconciliation and uphold the honor of the crown, deterrence is a factor to be considered. And so reconciliatory justice surely must also allow for that. Paragraph 142.
Sorry, what was that last paragraph reference on deterrence?
That's paragraph 128 of Southwind at compendium page 105, tab 9. I do not need to actually refer to 142 at this time. So all told, the errors are made by both crowns on the bring forward rate for different reasons. And neither of their reasons are reasonable or correct. Neither of them should find support in the court's reasons as being within the realm of anything that's just, liberal, or honorable. And a different bring forward rate should be determined by the court. I want to turn to another topic, which is item 8 on my outline, which is the Crowns have not justified their polycentric considerations. As we read Canada, Ontario's decision letters, the polycentric considerations are unexplained and not balanced in any manner that provides justification that this court can accept. The Crown's point here is that they must have their eye on the needs of other Ontarians and Canadians. But I want to bring this back to what the Supreme Court of Canada said. And the first place to start is at paragraph 296 of the Supreme Court of Canada decision, which is at tab 2 of my compendium, page 19. Towards the end, the discretion, or I'll start from the middle, the discretion must be exercised honorably, but also in accordance with Her Majesty's desire to be liberally and just with all her subjects. Well, that's fair enough. That's clear. To do justice to the Anishinaabe Treaty partners and Her Majesty's other subjects. Accordingly, in exercising its discretion, the Crown will have to engage in complex polycentric decision-making that weighs the solemnity of its obligations to the Anishinaabe and the needs of other Ontarians and Canadians. Well, that's a pretty fair and clear statement that there has to be some balancing going on. And we've already heard from Southwind that the obligations to fulfill treaty don't evaporate or because of competing interests. That's always been the case in fiduciary law. It's nothing surprising. Paragraph 296 isn't surprising either. The Crown has to balance is fine. But what has not been justified in any material way in the decision letters is why and how the needs of others would in any way be impinged or negatively affected by a just and honorable sharing of resource wealth. Remember, what's to be balanced is not just some general holistic notion of what might be due to what would be feel good to pay to the Anishinaabe. What must be balanced is this, what must be considered on the one case is the obligations to the Anishinaabe. And the obligation is nothing short of, and the Supreme Court of Canada says it a couple of times, to share the wealth where there is wealth to be shared. It's just a simple way of putting it, but that's what it is. Supreme Court of Canada puts it that way, essentially puts it that way as well. So then the question then becomes, okay, so what are the obligations to the Anishinaabe that need to be offset against the needs of other Ontarians? What are the needs of the other Ontarians? Why do the other Ontarians have to take, or why is a share of the resource wealth, NCRRs plus 25%, whatever you want to call it, where's the justification? Why does that need to be taken to deal with the needs of others? What are the needs of others? We just do not have anything. What we have is we have a claim that, oh, we have other needs. That's not justification. That's just an excuse. I want to remind the court, if I could, of the evidence from stage 3. And here it's at tab 10. This is part of the evidence from stage 3. Excuse me. Tab,
Trial exhibit 8 from stage 3.
sorry, trial exhibit 8,
David Hutchings report.
right? And so we're looking at compendium page 109. So just, I want to set the stage for you. What we have is we have Ontario and Canada saying, in effect, in their decision letters, trust us, judge, trust us, Anishinaabe. We have to look out for the needs of other people. Well, that's fair enough. But remember that the needs of other people could be satisfied from the other 98.2%, 99.8%. Yeah, math is hard sometimes. 99.8% of the other revenues the Crowns get. Now, the very next page, page 110, which is still part of the report, you'll see the revenues as a percentage of total revenues. The revenues from mining, forestry, lands, and water rentals as a percentage. And you'll see just how minuscule it is in 2013. And even as far back as 1913, it was only 30%. And it goes down dramatically after that. The point is that we have to remember that this pot of funds we're talking about is a minuscule fraction of the available wealth that the Crown has to call upon to meet the needs of other Ontarians, of other Canadians. There's just zero explanation as to why these funds are needed to be balanced against other Ontarians. What I would have expected to see in the decision letters is, here's what we need, why we needed the money. I expected something in the nature of, we had polycentric important needs of others, we had to address it, and here are the times, here are the reasons, but we really don't have any of that. We've just got a trust, basically, trust us, we know what we're doing, we're the government, and we have other needs for the money. That's not good enough for justification.
What if they said, we've got tariff problems coming down the pipe? Would that have been enough?
We could have, that would be a partial explanation, yes. And I myself, and we conceded, the Anishinaabe conceded, there might be times when there are challenges, when payments needed to be deferred, and we used as an example times of war, times of depression. Ontario picked up on that and indicated that there were times then that probably there wouldn't have been payments made.
But they didn't accept the notion of defer.
No, they didn't accept the notion. They didn't even engage in the notion of defer. That's a problem, right? But what we acknowledge that if there's good reason given, and the tariff problem in 2025 may, if they, I suppose if there was a real genuine exchange and discussion among treaty partners, that could have been something, but it was just very much nascent as we were ending. And to be frank, I mean, if there is evidence that it creates such a demand on the state that it is a pressing need, you're likely to find that the First Nations are not going to, I mean, it's always, for the First Nations, it's a sharing thing. And for the First Nations wouldn't say, we're gonna forget about our other Canadian brothers. They wouldn't say that. So yes, the tariff issue could be I think it's a good example of where there could be polycentric considerations. The problem is that polycentric considerations come into play every now and then, right? And that doesn't mean that you avoid or say that you can't honor your obligations. And I want to use an analogy.
Excuse me.
Yeah.
The reason I asked the question was, what if it had been that plain, that unaddressed? There are tariff issues. You say that we got nothing. What if they said we're just reading the newspaper like everybody else, and we see big troubles coming?
Right.
Would that have been enough?
Well, there could have been a discussion about that in the engagement process, but let's suppose that in the decision letter, it said, because of the tariffs, we're going to have to spend an extra $55 billion this year. And this is our estimate, right? Then we could have engaged in whether or not a continual call on $55 billion per annum is a problem. Now, with deficit financing, it may or may not be a problem. It depends on whether or not you're keeping up with your GDP production. And there is evidence in the engagement process, by the way, of two important points. In the engagement process, there was evidence that the Crowns didn't grapple with, I don't think they grappled with, is that I think it was in August of 2024, there was reports from the government of Canada saying that they could, and I'm just going from memory, but I think I'm going to be pretty correct, that they could incur $40 billion annually in additional spending without materially affecting the economy. This was their own report. We also know that Ontario at the same time chose to spend, I believe, $6 billion on a giveaway, which some people might say was an election ploy. But in any event, it was a choice that Ontario made to give away $6 billion to people at the rate of a couple $100 per person, when it knew it was facing an obligation to pay the Anishinaabe. So is that a fair polycentric concern to say we'd rather prefer, is it a policy consideration to prefer paying voters than to honor constitutional obligations? No, an honorable treaty partner would say, this is a constitutional obligation. Lining the pockets of ordinary Ontarians should take a back seat to honoring our constitutional obligations. That wasn't done. So even in 2020, as we were entering 2020, before the tariffs, there was money. And my answer to the tariff situation is, if there was evidence that they needed an extra $55 billion in 2025, that doesn't mean that the obligation dissolves. It means that the honorable treaty partner would work with the Anishinaabe. How can we work together to get you paid later? You take a back seat now, we will help you and honor our promise to you later. You might recall, if you've read the material, that that's exactly what the Anishinaabe offered. At any time, Canada and Ontario, if you tell us or the judge that you have any current fiscal problems in paying us, we will work with you to defer the payment over time. There was no response to that other than a rejection of it. That's not honorable engagement. That was a completely reasonable approach that the Anishinaabe were taking. We understand that you might have a fiscal problem in 2025. We're willing to work with you. We got nothing back in return. A one-time fiscal problem is not the way to solve 175 years of neglect. You can't, it's unfair and unjust and dishonorable, even if the tariff problem had caused them $100 billion expending and they had nothing to spend in 2025. Just because this court case comes in to be decided before you in 2025 is not the answer that they get absolution for 175 years of neglect. No, that's not honorable. What is honorable is to work a way around the problem to make sure that the treaty promise is honored, notwithstanding the needs of others. When the Supreme Court of Canada had in mind the needs of others being balanced, it was a present and future concern. It was a concern about what's the government going to do if it needs money. It can't spend $126 billion right now. My gosh, that's, I think they said 2/3 of Ontario's annual budget. I think if I might be wrong on the exact amount, but the point is they said it's a lot of money. And at the same time, they said they shouldn't, be worried, shouldn't be able to complain about sticker shock. But the idea that the crowns should have room to maneuver is fair. We don't object to that. What we object to is that using that to dissolve away the treaty obligation, especially since they didn't turn their mind as to how the needs of others could be addressed with other funds that they had. They didn't even really identify what the needs of others were. Canada appended at the last moment a fall fiscal update, but that doesn't really help them other than just say there's a general problem. It doesn't really dig down into an explanation why the Anishinaabe should be asked to sacrifice what would otherwise be payable to them. Because that's what's being balanced. What the annuity should be paid versus the needs of others. I want to remind the court what the Supreme Court of Canada said at paragraph 294. At paragraph 294, which is at my compendium tab 2, page 18. And this is the middle of the approach. I'm going to start at the beginning, actually. They quote from Professor Roach, and they say, Professor Roach's comments are instructive in relation to treaty rights. As in the charter context, it is true here that an appropriate and just remedy must employ means that are legitimate within our framework of our constitutional democracy. A court ordering a charter remedy must strive to respect the relationship with the separation of functions among the legislature, the executive, and the judiciary. The amount by which the Crown might increase the annuity is a polycentric discretionary determination that will inevitably, and now here the court is talking future tense, will inevitably reflect many social, economic, and policy considerations that may change over time that affect, one, the frequency and nature of net revenue, and two, the annuity calculations. That's prospective. That's looking forward. Now, the court then says, determining the amount of compensation owed for the past will involve similar considerations. I stress that courts are not incompetent or unable to entertain these considerations when necessary. Indeed, I acknowledge the jurisdiction of the courts to order compensation at stage 3 if it's appropriate to do so. What I want to focus in on is that the polycentric choices in respect of past compensation have been made. The actual historical Crown benefits captured have happened. There is no discretion today about the past. The discretion about the past is about the ability to pay today.
Let me see if I get that. When you say the discretion has been exercised, that is the discretion you have referred to earlier about how and when to manage the resources.
And what was actually extracted,
What was actually extracted, how, when to create rents.
or to create NCRR, net Crown resource to create revenues from resources.
But there was no discretion exercised with respect to paying annuities.
No, there was not. Now, the question of discretion, of retrospective discretion about share is a different issue. Let's deal with that in a second. But the discretion about the past, about what revenues were generated, it doesn't make sense. When the Supreme Court of Canada is saying there will be times in the future when the frequency and nature of net revenue will be affected, that's saying to the reader, to me, that the Crown has to be given the space to decide how it's going to extract resources in the future. Now, we would hope in the future, as there's an ongoing relationship, we, the Anishinaabe, can work together to figure out how, in keeping with UNDRIP, those resources are exploited to the mutual benefit of all. But that's a future discussion, not for these proceedings. For these proceedings, the polycentric considerations that gave rise to the quantum of what was captured is done. The frequency and nature of net revenue is done. When it comes to the annuity calculations themselves, the only thing left to be done is some sort of retrospective consideration of the share in any particular year. That, the Crowns have said, that there could be periods such as war and depression when they likely would not have made payment. Indeed, Ontario does exactly this. Ontario, in its reasons, postulates, well, maybe there were times in the past when, during times of war, when they probably wouldn't have paid annuities, even if there was a surplus, because of these pressing, we wouldn't have paid you your share because of these pressing needs. I think that is not an unfair thing for Ontario or Canada to say, that, to at least engage with that question is fair. Ultimately, what Ontario does with that is they do not reduce the amount payable. And if they would have been so inclined in 2025 to use such retrospective considerations touching upon the share of past annuity calculations, what Ontario and Canada both fail to do is to advert to the important evidence before them, as explained by Mr. Hutchings, that in times of plenty, that deficit, together with interest, could have been made up. And this comes from Hutchings' December 2nd, 2024 report, tab 11 of our compendium, at page 2713 and following. Or 2712 and following, actually.
The record then.
Of the record. Yes, I'm sorry, it's tab 11 of the record, page 125 of the record. Yes, I keep on saying record, I mean compendium, my apologies. Tab 11 of the compendium, page 125 of the compendium, starting at paragraph 27 of Mr. Hutchins' December 2, 2024 report. He talks about the federal and provincial governments, how they would have fiscal capacity to make up the difference. Now, I wasn't thinking about tariffs at the time when I asked Mr. Hutchins to opine on this and to provide data on it. I was thinking of, well, what if the needs of others in retrospective analysis, you would think that if there was a deficit, maybe that means that all the money's spent. And if there's a surplus, well, then you've got some money to share. So I asked Mr. Hutchins the question, well, assume that they only pay annuities when there's a surplus. When there's a deficit in the overall coffers of the provincial or federal government, give them a pass. What would be the result if you did that? Where would we end up if we only asked for annuities in the years in which there was a surplus at the end of the year? But I asked him to assume one more thing. Assume that a good treaty partner would have wanted to make up for the share that they couldn't pay because of the needs of others in previous years. And the answer was, it's pretty much the same up until 2008, because after 2008, there haven't been any surpluses.
And it's not in recent memory.
Right, no. There haven't been surpluses since 2008, but the result of the final figures is not that much different. The final figures still come within a very what it leaves on the table is a balance of, let's see, I think $318 million wouldn't get paid of Mr. Hutchins' analysis. So most of what Mr. Hutchins' analysis was, it would still get paid. And the reason why we wanted Mr. Hutchins to do this was to remove the argument from the Crowns that in times of need of others, they wouldn't be able to pay the annuity. And the answer was, well, yes, you could. You could just defer it. Defer it until you do have a surplus. Then you can use the money for us. We will wait. Did not get a response to that. We got a response. It was no, thank you. It's a rejection. No genuine consideration of such a reasonable approach. Now, aside from what I call the red herring approach of times of war and depression affecting past calculations, there is simply no analysis as to what the other social, economic, and policy considerations were in the past or presently are, other than the fall economic statement generally referring to tariffs. One could fairly surmise that the past polycentric decisions favored settlers at the expense of First Nations, but we don't know because the Crowns did not articulate or explain what those past polycentric considerations were that affected the social, economic, and policy considerations that would have said, my gosh, in this year, we can't honor our promise to you. Here are the needs of others. The court simply has no explanations to evaluate the merits of their polycentric considerations. Whatever they are not articulated. There is simply no justification. There is but an assertion of expertise that they can consider polycentric matters. And they ask the court to accept that. Respectfully, the Supreme Court of Canada says this court can know about polycentric matters. It can learn just as much as the Crown's agents can learn about polycentric concerns. All the Crowns have to do is bring forth evidence for it to be tested. They did not.
Well, I don't think the Supreme Court was presuming that there would be evidence to be tested in that engagement process, did they?
Yes, I think they did, because they said that the Crowns must explain why. If you're going to explain why the needs of others prevent you from fulfilling your treaty obligations, tell me what the needs of others are. Tell me why you can't fulfill the treaty. Don't just simply say, it's our expertise, we're the executive, and we have tariffs to pay. That doesn't cut it. That's not justification. That's excuse. That doesn't meet the test of honorable engagement. That doesn't meet the test of honorable result. I see we are at the hour of 4:30, and I'm ready to move on to another topic for tomorrow morning, unless the court has any questions about what I've said today.
Well, thank you very much. So we'll break for today. How are you doing on your timetable?
I'm doing pretty good. I think I might be finished tomorrow.
That's a warning.
Perhaps if people are ready to go when I sit down, then great. If not, I don't want to rush people if they're not ready.
Okay. All right. Well, I'm sure people will be ready when you.
Yes, I would hope so. With the little advance notice that we've just given them, they will be ready.
I believe we're up next. I can confirm we'll be ready to go as soon as Mr.
There we go.
Even if that is.
I was going to say that. Well, there's engagement. We just gave you a warning call from across the room. All right, so we'll break now, and we will convene at 10. And if there's anything we need to know, I'm sure there'll be communications. Thank you all.
Thank you.
All right.
The score is adjourned until tomorrow at 10 a.m.